start. Please take your seats, and we're going to start with the next workshop. For about an hour, we're going to talk about legal issues as well. So if you have any legal questions, Guy is the man who can answer any of your questions. So you are in the right place and the right time here. So
thank you.
Enjoy.
Thank you. Yes, so this is a funding bootcamp. I am going to talk specifically about some of the issues arising for funding and some of the legal stuff that comes up. But I'm also just going to give a general overview of a lot of the kind of legal areas that startups have to deal with. And this should, having an understanding of what the legal issues are, should help in terms of having discussions with investors and potential employees. Having an understanding of what the potential risks are is always quite useful. Now, we cover quite a bit in this talk, and I'm going to have to rush through some areas in order to fit into the hour, because I really do want to try and cover as much ground as possible. The first bit is the easy bit about business vehicle. I was just speaking to someone about converting a sole tradership into a limited company. For the vast majority of you, the only vehicle you really need to think about or use is the limited company. You're here on a sort of workshop about funding, and frankly it's almost impossible to get third-party external funding into any business other than a limited company. Limited liability partnerships are used for professional businesses and joint ventures, but I've never seen one for a tech startup. Similarly, the issue with being a partnership or a sole trader is that there's personal liability attachment. So essentially, limited company is probably the only vehicle you'll ever need. The requirements for setting up a limited company are pretty straightforward. Many of you have probably done this already. You could do it online with Company's House. I'm talking about the company registered in England and Wales. But it is one of the easiest jurisdictions to register a company. It takes about 15 minutes or so. So you need to have at least one director and shareholder, and that can be the same person. So you can have a company that's effectively one person. You need to file an annual return once a year, explaining who the directors are, who the shareholders are. You need to file annual accounts. You can delay your first accounts until up to 18 months after you start to trade, and then you have 9 months to file your accounts. So you can avoid filing accounts for up to 2 years if you really need to. You also need to tell Company's House about changes to directors and a few other things. If you have battable supplies of above £83,000, you need to register for that. You have to do that, although many of you may avoid doing that until you hit that threshold. And you may also need to register and pay corporation tax. The rate is 20% of the I'm sure you know this corporation tax goes to tax on profit, so until you have any profit, there won't be any tax to pay. So although I said that setting up a company is very easy, very straightforward, you can do it online without even really thinking about it, you do need to be careful, because as soon as you set up a company and appointed yourself as a director, you are from that point on subject to some quite onerous duties to the company. From that point on, you have to act in the best interests of the company, which may be different to your interests in some scenarios. You have to act with reasonable skill and care, not be subject to a conflict of interest, and not prejudice other shareholders unfairly. So these apply if it's a single member company. These duties always apply for so long as you're a director. I do just want to talk about the last one, not to prejudice shareholders unfairly. That's technically not a duty, but kind of a general rule that applies, that protects minority shareholders in particular against majority shareholders doing things which are unfair. So the classic example of unfair prejudice is if you were to give shares to someone and then regret giving shares to that person. So let's say you gave 10% of your company to someone who you're planning to take on as a CPO. They went on to other projects, didn't deliver anything for you. If you give someone shares, you can't force them to hand them back unless you've got a contract in place to say you can do that. So what a lot of people do is go down the alleged kind of Mark Zuckerberg route and try and dilute them down. So I've got 95 shares and I own, he's got 5 shares. I'll dilute him down, so I'll issue myself with 10,000 shares, and all of a sudden his shareholding is worth virtually nothing. Now, if I were to do that, then that would amount to unfair prejudice, and that shareholder could bring a claim against me if they wanted to do so. They might not bother, but they could do. So you do need to be careful. And that example of giving shares to someone without having an agreement in place is probably the most common serious mistake that we see startups make, is that they give equity out before having the documentation in place. And there's sometimes an assumption that if someone doesn't do what you thought they would do or what they promised to do, you can get the shares back. That's not the case unless you've got a very clear contract, and that's usually what a shareholder's agreement is for. But I'll talk about that a bit later. Just a few of the sources of capital there, founders, friends and family, bank loans, business angels and crowdfunding. I'm sure you're all familiar with how startups can get money for financing development. I'm not going to cover institutional fundraising. That's a big topic in itself. And that's obviously for slightly later stage companies generally. Co-founders may decide to put some money into their own company. They could buy shares and, if you like, pay for equity, or they could lend money to the company. With co-founders, it's nearly always best to lend money to the company. If you've got a new company, you can issue yourself shares for £1, and then if you've got 3 co-founders and they're all putting in £5,000, better to lend that money to the company because you can repay the loan back tax-free, whereas if you buy equity, the only way to pay people is through dividends or salaries or fees and services, which are all taxable.
And do you do that in proportion to their incentive? Sorry.
You sometimes do, but you don't have to. So sometimes you'll have unequal percentages and equal loans going into the company. But often it is an equal. Obviously, friends and family may lend money as well. Or friends and family are more likely to buy equity. But for any investor other than the founders, as founders, you want them to buy equity. Because if they're lending money to the company owes them that money. So for anyone other than a founder, you probably want them to buy equity as a preference rather than making a loan. Obviously, banks could be available. Banks very rarely lend to early stage startups without security. So if you're not happy to give a personal guarantee or to put another charge on any property you might own, you're probably not going to have much luck with banks. Although you may be able to get small unsecured loans, which may be quite helpful. Probably advise against that. Then obviously the biggest source of significant finance for startups in the early stages tends to be angels, who can, although don't always, provide advice contacts. And if you have an angel investment, you will almost certainly need a shareholders or investment agreement, which I'll cover. Just a word about crowdfunding. Some of the crowdfunding is starting to mature a bit now. Some of the hype, some of the heat has gone out of the idea of crowdfunding. I think the idea that you can go onto a crowdfunding platform with a great idea and not much else and get significant traction is has faded a bit. It's very difficult to do that. But what a lot of people do is use the crowdfunding platforms to secure finance from an existing network of people. But sometimes a business has built up a customer base and wants to tap up that customer base for investment. You can't just email all of your users and say, do you want to invest in us? That's illegal. But you can do it if you go through a crowdfunding Similarly, you might have a personal network which you think it would be useful to raise finance through. Can be a bit risky just to email people asking them if they want to invest, but if you go through a crowdfunding platform, it may be a good way to tap up your personal network for financing. And the best thing is they deal with the admin and they deal with the financial services regulation, so that you can be, sure that everything you're doing is legal. Many angels and sometimes founders can benefit from EIS and SEIS relief. You've probably heard the terms used quite a lot. They're very generous tax benefits which apply to investors. So if investors invest in early stage startups, they can get an immediate rebate on their income tax in that tax year, and there's no capital gains tax to pay on those shares when they sell them. So it's a very generous tax benefit. There are various restrictions, so you can't have more than 30%, and you can't be an employee. That usually means that founders can't benefit from EIS and SEIS relief, or it's a lot more difficult. The investor, I'll just call it the investor now. The investor can't have a preferential right of return, so they can't have what's called a liquidation preference. They can't get their money out first. Their shares have to be what HMRC calls full-risk shares, which as a founder is a really good thing, because you don't want to be giving people preferential rights if you can avoid it. And with EIS, you can raise up to 5 million, and it applies to SMEs, and I think all of you will be SMEs. Test is you have to be quite big not to be an SME. SEIS is an even more generous relief than EIS. It's more generous to the investor, makes no difference to the company, but much more generous to the investor. And you can raise within 2 years of starting up to £150,000 per company, but you can only get £100,000 from only one investor. Now, your SEIS relief is an asset for the startup, and it's a wasting asset after 3 years. So if you can use it and you need the finance, then you should try and use it. What a lot of startups find is that getting that 150 is easier than getting the next one. But yeah.
So did you say that you're only eligible for the second one if the startup is less than 2 years old?
2 years since it started to trade.
Okay, since it trade.
The company could have been formed before then, but it's 2 years from it started to trade.
And is that the same with the EIS?
No, there's no time limit for that. You just have to be a small company.
And there's no lower threshold for the investment for
Yeah, 5 million.
lower level.
So
What's the entry level for those that become eligible?
there is no minimum.
Oh,
So there's no minimum investment. As a company, you can raise up to 5 million on EIS and up to 150,000 on SEIS. An investor can only invest up to £1 million across all the companies they invest in EIS, and they can only invest 100,000 for SEIS. But there's no minimum. You could, in theory, spend it on £5. There is no minimum. So, if you have more than one founder, or if you are raising money from an investor, in either of those scenarios, we recommend that you have a shareholders agreement in place. If you have investors, it might be called an investment agreement. It might be called a subscription agreement, but they all effectively mean the same thing. It means an agreement between the shareholders of the company. Now, all companies also have a document called the Articles of Association. And what goes in the articles and what goes in the shareholders agreement is often not that clear. Generally speaking, though, the articles are public documents, so you can see the articles for any company registered. You go to Companies House and download their articles and so on. So anything that you want to keep confidential, you don't put in the articles. The shareholders agreement tends to include personal terms, so terms that apply to individual shareholders. Non-compete covenants, vesting, that kind of thing. Although you can have vesting in it. And then share transfer rights how and when you're allowed to transfer shares. That can go in either document. These days, though, it's becoming a bit more common to have the share transfer stuff in the articles. So, what do you need to think about for a shareholders agreement? Even if you haven't got an investor, again, I emphasise that if you are a group of co-founders, you do need to be thinking about this stuff. Especially if you are a majority founder, or you're currently a majority founder, and you're looking to give equity to other people, you need to discuss some of these things. Because as I said, once you've given away equity, it's quite hard to go back. You need to think about who's on the board. The vast majority of decisions in a company are taken by the directors. The shareholders of the company take virtually no decisions at all, other than to decide who the directors are, and a few other decisions that are reserved by the company. But the vast majority of things that the company will do will be decisions of the directors. Contractors, on the other hand, they're a more flexible resource. They're not on the payroll, they will invoice for their fees. They have to pay their own tax. They don't qualify for many benefits. The key point is that a contractor, the kind of philosophical difference between a contractor and an employee is a contractor is doing their own work for the company, and an employee is doing the company's work under the same direction. So a contractor has a certain amount of independence, simply speaking. You do need to be careful that contractors are genuinely self-employed. If you call someone a contractor, but really they're an employee, HMRC can pursue you for the tax that hasn't been paid. They can go back 6 years, and it is you as the employer that's liable in the first place, not the employee. So even though the employee may have benefited from not paying the tax, it's you that have to pay that. So you do need to be careful when taking on contractors that you're not hiring disguised employees and calling them contractors to keep easy. So one of the things you need to do is have a contractor's agreement that sets out the terms of the contractor. That isn't inclusive. You can have a contractor's agreement and HMRC can still say, actually, we think it's they're an employee. And note that a contractor is still a worker and can still benefit from certain rights. So, for instance, contractors still have the right not to be discriminated against. That applies to all workers, not just the employees. So, these are statutory rights for employees: holiday, family leave, minimum wage, protection from dismissal, pension contributions, redundancy compensation. And you have to give employees a statement of terms within 14 days. I'm not an employment lawyer, so I can't tell you exactly what all of those rights are, but you do need to be aware that there are various rights which employees are entitled to. They're generally not that onerous for startups. Interns. So this is quite a new slide because I've got quite a lot of questions about interns. Now, unfortunately, or fortunately for the interns, it's very difficult to hire an intern without paying at least a minimum wage. You do need to pay a minimum wage to interns unless they're in a formal student program. That doesn't mean that they are a student, it means that you're in a program with the university or the college, and that they're doing the placement. Or if the intern is a voluntary worker, if you're a for-profit company, you won't qualify for that. Or the intern is work shadowing only and not doing any work. So if they're really just coming in to see what's going on and they're not delivering any work of value, you don't need to pay them. But as soon as an intern is doing some form of work for the business, they should be paid the minimum wage. So those minimum wage rates are a bit out of date. There's now a new higher rate, so that 670 is now 720 I think, for people aged 25 and over. And then that is for people between 670 is for between 21 and 25, and then the others are 530 over 20 3 times
7 under 18.
Advisory boards. Many of you may be talking to advisors already. You may want to take on advisors who can offer you contract assistance. Usually an advisor would get a small slice of equity in exchange for their time. One of the biggest mistakes, again, is giving equity without getting a commitment in return. So we would recommend that you have a contract with your advisors, setting up what's expected in terms of time commitment, how many days a month is the advisor expected to work for the company. And if you do give the advisor equity, we recommend that it vests over a period of time. So if things don't work out with the advisor, you claw back some of the equity. Generally speaking, we would say that an advisor contract should be terminable. You should be able to get out of it without, there being something wrong on the part of the advisor. So in other words, you can terminate for convenience and not for cause. That's because when things don't work out with advisors, it's usually not because they've done anything wrong. There's usually just a mismatch of expectations. They're not quite delivering. So given that you put equity on the line, you want to be able to get out of that contract if it's not working out. Okay, so you may wish to give staff equity separately to advisors and co-founders, and certain members of staff will expect equity in a startup, especially if they're being paid less than a market salary. Two options are: one is to give equity directly, so just issue shares to the employee, or you can give the employee a share option. It can be a tax issue to just give shares to employees. If the shares have a value, the employee could be subject to tax on those shares. So usually it's better to have an option. As well as the tax advantages, you can put in place performance conditions, and the options can be exit only or vesting. So vesting option is an option which allows the employee to get a certain number of shares over a certain period of time. An exit only option is an option which isn't worth anything unless the company is sold or listed. So in effect, and usually it would lapse if the employee leaves before the sale or the listing. So unless for the employee to benefit from the option, they have to be there until the company is sold. If you do issue equity, make sure there's a shareholders group in place. All your articles have got terms covering employee shares. Yeah.
So what's the difference between equity and share?
Equity, when I say equity, I just mean shares. So the difference is that a share option is a right to buy a share in the future. So if you grant an employee a share option, you're saying that if certain conditions are met, you will be able to buy shares in the future. So they're not a shareholder now, they've just got a piece of paper that says they could become a shareholder in the future. So I should be clear on that. And an exit-only option allows the employee to buy their shares only if the company is being sold. So if you've got an exit-only option, you're probably actually never a shareholder, because you exercise an option immediately before the company is sold, and you just sell your shares straight through and collect the cash. But yes, and obviously if the option vests, you can have a time period, so you might say that the employee has to stick around for a year or 18 months in order for any of the option to vest. And if there's a minimum time period before any of the option vests, that's sometimes called a cliff. So if you talk about an option vesting over 2 years on a straight line basis with a 6-month cliff, that bit of jargon just means that if they leave within 6 months, they don't get anything, and none of the option is vested. And then 6 months, the previous 6 months vests immediately, and then the rest vests over the remainder of that 2 years. Okay, the final topic, which I will try and cover in 10 minutes, is just about your business operations. And and dealing with risks and liability for the business. This is quite a difficult one to do because I don't know what your businesses are and it varies so much. But I assume that most of you have got technology startups, but not all of you. And the liability issues you face will depend on the type of business you are. So if you are manufacturing products, you need to be aware of product regulation. So if you are making or selling bicycles, it's quite a highly regulated example. In Europe, there are a whole series of product regulations that you have to meet in order to sell bikes in Europe and anywhere in the world. There's also product liability. If your product causes an injury, you are likely to be liable for that injury. So most businesses that sell any form of product will have insurance in place against that. If you're selling services, then you could be liable for professional negligence if you fall below the standard of care which is expected of you. When I say services, I don't just mean lawyers and accountants and that kind of thing. But if you've got an app with some form of functionality, you may well be providing services of some sort. Some services themselves are regulated. Financial services, obviously highly regulated. But also gambling, recruitment. There are various services which are subject to specific regulations. The most common ones in startups do seem to be financial services and gambling. There's quite a lot happening there. If you've got a platform, if you've got by platform, if you've got some website, app, product that allows people to interact with each other, users to interact, and users are generating their own content, then you could be liable for defamation, IP infringement, unless you take certain steps that I'll talk about in a minute. But you do need to be aware of those risks of users using your platform to distribute pirated content, using talk boards to defame each other. And you also need to be aware of your data protection obligations. I've got a slide on that. And your advertising standards obligations. So all websites and probably apps that are tested are now covered by the advertising standards regulations. What that means really is that any claims you make about your product have to be true. So bear that in mind. I'm sure there would be anyway. But if you make a claim on a website that you are doing something which is patently untrue or misleading, then you could be liable for breach of advertising standards. And if you're selling to consumers, be aware that there are various rules applying to consumer contracts. If you're an e-commerce startup selling products to consumers, you need to be aware of the distance selling regulations, which give a 14-day cancellation right after the consumer's received the goods. And in any contract with a consumer, terms which are fundamentally unfair will not be binding. This applies across Europe, the European directive. You do need to be careful that your terms are not from any one term. If it was fundamentally unfair to the consumer, then it would not be binding. Insurance, I often ask what insurance do we have to have, what insurance should we have. The only compulsory insurance is employer's liability insurance. If you have employees, you do need to have employer's liability insurance. Most businesses also have public liability insurance, because it's not very expensive. And that's kind of general liability for injury or loss arising from your business affairs. And if you're a services business, you probably also need to get professional indemnity insurance, which covers negligent services. And often, in practice, you buy what's called a combined office policy, which is one insurance policy which covers everything you need. I'd certainly strongly recommend taking out insurance. It's not very expensive and could be very useful. So some questions to ask: is your sector regulated? If so, you obviously need to think about those regulations and look them up. Are you dealing with consumers? In which case, consumer law applies. International regulation. Judgment call to be made about international regulation. If you do publish on the App Store, you might be in many countries. You need to look up the law in every single one of those countries. Well, it's going to be impossible to do that anyway. What I say is you have to exercise some judgment and probably have an understanding of what the law is in those countries where you're aware of there being a significant user base or where you are actively targeting users. But clearly, you're not going to be able to look up what the law is in every country where your website is available. You do need to identify your business relationships, who are your suppliers, who are your users, who are your customers, and then make sure you have terms and conditions or terms of use for each one of those relationships in writing. So I said I'd talk about user data. You can be liable for defamation, IP infringement, for things that your users do on your website or platform. But this can be managed using a notify and take down procedure. So if you operate a notify and take down procedure, what this really means is you give people an opportunity to report infringing content, and if people report infringing content and you take it down immediately, then you will not be liable for that infringing content. Similar rules apply in the US and in Europe now. And the question is, how quickly do you need to act? Well, you need to act within 24 hours, one court has said. So if someone does report infringing content on your site, you need to move very quickly. And in terms of data protection obligations, it's quite important to put in place a privacy and data policy. And your obligations in relation to data protection are fairly straightforward. You need to tell people what data you're collecting from them. You need to tell them who you're going to disclose data to, and you need to preferably get their consent. Now, you can operate on the basis of opt-out consent for most things, most of your day-to-day business activities. But if you're going to be disclosing personal data to a third party, you need to get the express, opt-in, informed consent of the person whose data you have. So, and when I say personal data, that's any data which could be used to identify an individual. So, names, addresses, phone numbers, and any information about those people. So, quite a wide category. But generally speaking, if you've got a well-done privacy policy and you're not disclosing data to third parties, and you're taking proper steps to secure data, you don't need to be too worried about data protection regulation. Okay, so that was it. Just under an hour. I'm with Russell Cook. We do a lot of work with startups. We have done for many years. We operate a startup legal pack, which includes a free consultation and advice on kind of your business and what you might need. And then you can go elsewhere and use us as you wish. And many of our services are offered on a kind of fixed fee basis. So, I'd be delighted to speak to any of you. Those are my contact details, and I have got a few business cards as well.